Good afternoon. Good afternoon to everybody present here today, the respected scholars on the dais. I'm an economist, and this is a post-lunch session. We are known for boring people to death. I'll try not to do that today. The Indian Constitution is having a special moment. The leader of the opposition waves it around, the treasury benches often talk about it, amendments are made, changes are talked about, and we pay a lot of attention to it. It is a haloed book, but it never started out that way. The Indian Constitution was never a document of consensus. The Indian Constitution is a document of managed dissent. Who manages the dissent, and by what authority, is the central political question of the Republic. It was the question on 24th of January 1950, when the Constituent Assembly met the last day, and it was the question that we ask today. On 24th January 1950, 2 days before the Constitution came into force, the Assembly met. 3 years they had argued, they talked about. You would imagine it would be a day of triumph. It wasn't. If you read the document from that day, one of the most important warnings was cast across the spectrum, be it Baba Saheb Ambedkar, be it Dr. Rajendra Prasad, who was to serve as India's first president. Every member in that room was aware of the fact that this document was a compromise. The drafting committee had accepted provisions it disliked and made its dislike absolutely clear. Members had fought battles and lost them. The directive principles were aspirational because the Assembly could not agree to make them enforceable because India was a poor country. The emergency provisions were wide because the partition was recent and the fear of collapse was real. You had somebody sitting in England, Winston Churchill, who just won a war but lost his own government, who had warned that the Indians cannot really run a government. So this is the backdrop on which this constitution came to be. What strikes you in record of that final session is how many members stood up to register their dissent. Not with the constitution, they had voted for it, but with specific choices they believed would carry consequences. And boy, they were right. Those consequences matter today, perhaps more than they mattered at that point of time. We made this museum because on a trip to Bihar last year, I had a realization that what we take for granted about the Constitution is something that people in the villages, in states that are far away from the minds of the politicians, the bureaucrats, the technocrats that run our country today, the Constitution is a very vivid document, but they've never seen it. They've never been made part of it. They don't know that there was a tension that created this book. They don't know that this managed chaos is what makes this country an aspirational country and a great country, and a country, if it is going to be what we believe that it will be in 2047. They need to understand the Constitution, not just pay obedience to it and give it halo terms. Because a democracy that forgets why its rules exist cannot defend those rules when they come under pressure, and we will come under pressure because chaos is a human condition. Let me turn to the most consequential constitutional moment since the founding. I am not a legal scholar, I am an economist. I have no standing to speak about legal matters, but here I go. Keshwanand Bharti versus State of Kerala, Supreme Court, 24th of April 1973. The facts are almost besides the point. Keshwanand Bharti was the head of a Kerala mud. He challenged the state's ability to do land reform. This was an extraordinary case because the Supreme Court decided that this would be the case, that it is going to take as an exemplar of what the democracy is and what the Constitution is going to be. The court used the Keshwanand case to decide a larger question. Can the Parliament amend any part of the Constitution, including fundamental rights, or are there limits? structural, implicit, beyond the reach of any amendment, that even Parliament cannot cross. That question did not arise in a vacuum. It arose from a fight. This fight started in 1967. Much before that, but 1967, in Golaknath versus State of Punjab, the Supreme Court held that Parliament could not amend fundamental rights. The ruling was sweeping. Indira Gandhi government treated it as an obstacle. Land reform, bank nationalization, the abolition of privy purses, each dependent on a parliament with a room to maneuver. They decided that they had been elected by the people, they were the representatives, and they could do whatever they wanted. So they did. Between 1971 and 1972, the parliament decided that it would pass the 24th, the 25th, and the 29th Amendment. Each was designed to override a specific Supreme Court ruling. Keshwanand Bharti was the Supreme Court's reply. 13 judges, the largest bench ever assembled at that point of time in the Supreme Court's history, 700 pages of judgment, the vote 7-6. The doctrine that emerged is now familiar. All of you who are part of the law faculty, who read about it as political scientists, know it. The Parliament may amend any article. It may not alter the Constitution's basic structure. Some features, federalism, secularism, judicial review, the Republican form of government, are beyond the amending power, whatever, of Parliament's majority. Keshwanand is often taught as a clean victory for constitutionalism. It was not clean. I want to be precise about what happened. First, the margin. 7-6, one vote. The most consequential constitutional doctrine in Indian history rests on a single vote. Had one judge gone the other way, Parliament today would hold unlimited amending power. Every fundamental right, every structural feature of the Constitution would sit within the reach of the two-thirds majority. That was the position of 6 judges of the Supreme Court of India. Second, the aftermath. A day and a half after this case was decided, 3 senior judges who were in the order of precedence were superseded by A.N. Ray to be made the Chief Justice of India. This was without precedent. We often talk about precedent now, but this, I would like to remind you, was happening just a few decades after the Indian Republic was founded. Third, the doctrine itself. The basic structure is indeterminate by design. The court did not produce an exhaustive list. It did not say that this is the basic structure, you can do whatever you want here, you cannot do whatever you want in the other spectrum. It produced a principle and left the work of definition to later benches. It gives the court the flexibility to respond to constitutional threats it cannot predict. This is the feature of the Indian Constitution that I would like to underline to you and every citizen of this country. Every major constitutional case since 1973 has in some form asked the same question. What counts as basic structure? And who decides? Parliament? Supreme Court of India? Because the people of India are not implicitly available to decide it for them. Keshwanand was not the end. It was the opening of a pattern that kept on recurring. The emergency is the clearest example. In 1976, the Parliament passed the 42nd Amendment. It was passed over 50 provisions. It added socialist and secular to the preamble. It curtailed judicial review. It placed the directive principles of our fundamental rights. Indira Gandhi's government called it a corrective. Its critics called it a constitutional coup d'etat. When the emergency ended and the Janata government took office, the 43rd and the 44th Amendments rolled back much of the damage, but not all of it. The amended preamble still stands and is contentious to a large quarter. The NJAC case of 2015, and later followed up almost for 7 years, is another instance. It sought to replace the collegium system of judicial appointments with a National Judicial Appointments Commission that included executive representation. The Supreme Court struck it down. Judicial independence it held was part of the basic structure. The decision was controversial and it remains so, and it continues to be. It set 2 legitimate constitutional values against each other. Democratic accountability in judicial appointments on one side, insulation of the judiciary from executive influence on the other. Sensible people disagreed then, they disagree now. And they will continue to disagree, I hope, in the future, because disagreement is the bedrock of democracy. The abrogation of Article 370 in 2019 raised different questions. Could the Parliament alter the constitutional relationship with the Union and its state through an executive order, bypassing the state's own legislature? The Supreme Court upheld the abrogation, but the reasoning and what it means for federalism will be argued for decades, if not for centuries. I name these cases not because I want to take a side on any of them. As I said, I'm not a lawyer, but I am a citizen. I name them because they make a point about why the museum was built and what is the basic structure of the museum itself. The Constitution is not a sacred text. It is a site of contest. Every generation faces its own version of the Assembly's original question. What are the limits of state's power, and who defines those limits? It is available to you today. It will be something that will be a contest for your succeeding generations tomorrow. Indian public discourse tends to treat the Constitution in one of the two ways. As sacred, a document beyond question. You hold it up and you say everything that is happening under this particular regime is wrong because the Constitution does not agree with you. Or as instrumental, a set of rules to be worked around, amended, or reinterpreted as convenience requires. Both are failures of constitutional imagination. The first makes the Constitution into a totem, an object of worship. The second makes it into a tool, an object of use. Neither takes seriously what the framers actually did. They built a framework for the management of political conflict within agreed limits. This is the work. It is harder than worship and more serious than use. The Constituent Assembly debates are the best corrective to both the tendencies. They sit in the first layer of this museum, all 12 volumes, searchable by article and by speaker. Read the debates on preventive detention, Article 22. You'll find members wrestling openly with the balance between state security and individual liberty. Aware as they drafted that the provision could be abused, read the debates on reservation, Article 15 and 16. You'll not find clean supporters and opponents. You'll find an argument about duration, about scope, and about the relationship between caste and class. Something that political scientists, sociologists, anthropologists have refused to do even now. Read the debates and a certain idea collapses. The idea that framers were gods and the Constitution is a tablet handed down. They were lawyers, politicians, administrators, activists, and farmers. They argued, they compromised, they voted. The document is the record of their argument. And these are documents that you have to read if you're going to be a citizen. Doesn't matter if you're an engineer, you do work with AI, you do not work with AI, because your country needs you to argue the points, something that we have forgotten in the last 75 years. There is another dimension that I want to draw out. I am offended when I'm told about how great the American Constitution is, because the Indian Constitution, I will argue, is one of the greatest works of art. You know, the original manuscript of the Constitution was handwritten by Prem Bihari Narayan Raizada, hand illustrated by Nandlal Bose and his school at Shantiniketan. The illustrations run across 22 pages. Each opens a part of the Constitution. Together, they draw from the Vedic period, the Ramayana, the Mahabharata, life of Buddha, the Mauryas, the Guptas, the Cholas, the Mughal India, the Rani of Jhansi, Gandhi, and Bose. It is a visual argument about the civilizational ground on which the Republic stands. The visual program is itself a constitutional statement. The framers could have produced a typed document. We are talking about 1950s. They could have done a very boring, very bad-looking, very ugly book. They decided to create a hand-lettered manuscript. They chose Shantiniketan, Rabindranath Tagore, that says something about intent. The Republic is built on a civilizational inheritance, not severed from it. How that inheritance is to be read, whose India the illustrations depict, whose India they leave out, is a legitimate question. The museum opens this debate without trying to close it. This is your Constitution. Come on, when the museum is open, please take a look at it. and have an argument about it. The manuscript, the original one, is very rarely seen. It sits in a helium-filled case in the library of the Parliament. You cannot walk in and ask for it. The museum makes its visual life available to anyone with an internet connection, and as our politicians keep on telling us, we have the fastest growing internet connectivity in the world, so let's make use of it every once in a while for good things. The Constitution is not only a legal text, it is a national narrative. The illustrations tell you what kind of nation the framers thought they were founding. Whether that vision has been fulfilled is another question which I will leave to you to decide. Let me close on what this museum and who this museum is for. It is not a monument. We have a tendency in this country of making monuments. Museums and monuments are for things that are finished. The Constitution is not finished, far from it. It has been amended 106 times, as recently as last week, if I might add. It is contested in every session of the Supreme Court. It is invoked by every shade of political opinion, sometimes in ways that would have astonished the framers, sometimes in ways they would have recognized on sight. The museum is an instrument of constitutional literacy. We built it on a simple belief. The quality of a democracy runs on the depth of its citizens' understanding of their own constitutional order and morality, not reverence. We don't want you to revel the Constitution. Understanding is what we seek that you try from this museum. Engage with the Constitution. The framers disagreed on pretty much everything. It is very hard to find a good day in the Constituent Assembly. There is a book, Bharatiya Samvidhan Ki Ek Ankahi Kahani, written by the Chancellor of the University. You should read it. You would get an idea that it is managed chaos. But they agreed pretty much on this, that the Constitution belongs to the people, not to the lawyers, the politicians, or the judges. The preamble is blunt. It is ordained, we the people of India. If the people are to exercise that ownership, they need access to the arguments and the anxieties that produce the document. Granville Austin, one of the greatest historians of the Indian Constitution, and somebody I had time to read while I was floundering around in political science for a very short period of time, called the Indian Constitution first and foremost a social document. He was right. It is also a political document, a legal document, and as the manuscript illustration reminds us, a cultural record. This museum tries to hold all of that together. Whether it succeeds is for you to judge. Also, we are a small think tank within the SGT University, and we have a startup mentality. So we make things and then we keep on tinkering. So nothing that we ever do is ever finished, and we always keep on tinkering with it. That is what we do. Thanks to SGT University, I think they've given us a brilliant platform where we are able to do quite a lot of these interesting things and get away with it, especially the managing trustee of the university, Shri Manmohan Singh Chawla. I had a very short conversation, a very brief conversation with Dr. Hemant Verma last year, telling him that we should do it, and he agreed in a minute, thanks to him. Our chair, Shri Najib Jung, is an instrumental process of all of these things. There is a lot of, I can see the microcosm of Constituent Assembly in all our conversations. There is always a lot of dissent that one has to manage. So I have my sympathy and empathy towards all of the people who were in that debate, because it becomes very hectic at times. I would like to thank every member of the SGT University team, the law dean, who's been very kind and generous, and I would like to thank Dr. Sandhya Vasudevan for being here. I would also like to thank my good friend, Professor Hilal Ahmed, who has always been kind enough to review things at the last minute, and Amit Suman, who does the same. I would also like to thank Priyank Kanungo, because he has a lot of things going on at any given point of time, and he's taken the time to be here. There are a lot of people that I would like to thank, especially the interns who worked on it, and many, many other people. You know who you are. Thank you very much. Above all else, I would like to thank all of you to be here after the lunch session, sit through patiently what I can only imagine is a very boring speech. But I invite you, once the museum is up at www.livingconstitution.in, I invite you to use it. More than that, I invite you to argue with it. And with that said, thank you very much for your time.